One of the huge questions that I usually get asked, Peter, is, I'm waiting so long for this. I've waited so long at the SSA level. I've waited, 1 to 2 years at the federal court level. Like, am I going to be entitled to fees for this entire time that I've been waiting? And the answer is actually
Welcome to the Evans Disability Podcast. We hope to be your definitive guide through the Social Security Administration landscape. I'm Peter Evans, your host and managing partner at Evans Disability, a law firm that handles disability cases throughout the United States. Before we dive into today's episode, I want to mention a special resource for our listeners. Click the link below to receive a free SSA disability guide from Evans Disability. This guide is packed with details on SSA disability programs, expert tips for winning your case, and sample questions from actual disability hearings. Join me as I sit down with special guests, including experienced lawyers, our extremely well-trained staff, and even a former Social Security law judge. If you find our content useful, please hit the like button and don't forget to subscribe to stay updated on our latest discussions. I hope you enjoyed today's episode.
if you had, for some good cause, reason why you didn't get some medical evidence submitted into your file, and then the appeals council also denied to review that evidence, then that is an appealable issue that we can bring to federal court. But anything other than that didn't exist at that time of your hearing, you cannot add any new additional evidence for this appeal.
Right. And that's a good point. Thank you. Well said. The next question, and I think you did say this, but I get from clients is, do I need to show up to face this magistrate or federal court judge?
Right. So the good thing is that no, you don't have to show up anywhere. There's not going to be a hearing while your case is actually pending in federal court. So I tell a lot of clients, this is actually a great time for you to actually focus. And, a lot of clients are pretty upset, that they get denied by the appeals council and think, this is the end of the road. But this is a time where you can really focus on your health. You can focus on getting, more medical treatment and just, kind of sitting back and either letting the attorney kind of take the lead on this as much as you like, or you can actually, be as involved as you like with the attorney and kind of help them with the brief writing process as well. It's really up to you. But a lot of clients that we represent, I do tell them, let us kind of take over. I know this has been a really long and arduous process from the beginning of your application. So kind of let us do the legwork with a lot of the brief writing and focus on your own health. So thankfully, during the actual federal court process, no appearance is needed by the actual claimant.
Yeah. So, and that leads to my kind of next question is, well, what can I do? What can a claimant do? Can they start, and I get this question a lot, can I start a new claim with the Social Security Administration?
Yeah, so you can actually do that at the very same time that your federal court case is pending. You can start a brand new case, which is really great. And I explain it kind of as having a little bit of a backup plan if your federal court case isn't successful. So that at least we can kind of get something going as soon as possible for you.
Right. And one of the reasons I think that's good advice, and you got to look at kind of the technicalities of things. And I think hiring an experienced attorney with Social Security, because they're going to want to look at your date last insured. Is this Title II? Is this Title 16? And evaluate that. But you just said, and I agree with everything you said about this federal court case could take 12 to 24 months, where a Social Security decision could come back and a new application can come back about 7 to 8 months is what we're seeing. So potentially, you could win the second claim, start collecting your month-to-month benefits, while at the same time, we're fighting for, your lawyer in federal court is fighting for all that back pay. So it's not like you're letting that back pay go. It's just in a different, kind of two different cases.
Right. That's exactly right.
So let's talk about, before we talk about fees, because I do think fees is a huge thing that a lot of people ask. Talk to me about what are the options of the federal court judge to do with a Social Security case? What are kind of the different options that the judge or the magistrate has?
Sure. So there are three main things that can happen. One is obviously the federal court judge can agree with the SSA judge and the commissioner that your case is not, indicative of a disability, and they can affirm and dismiss it. That's the most that's the least common. That kind of comes from our experience and our clients, just because we do a lot of review at the beginning, and we don't want to give any false hope to any of our clients and saying that you don't at least have, a shot at being successful. So that's actually the least common in our particular firm, just because we do so much upfront review. So that's the first thing that could happen. The second and the most common thing is what's called a reversal and a remand decision. And so basically what this means is that if you get that sort of decision, the federal court judge is agreeing with all of our arguments that we've made in the opening brief and also that reply brief that, hey, this SSA judge made all of these legal errors. We need now to send the case back down for that same judge usually to reevaluate all of the evidence that was there prior, fix their analysis, and also allow for any new evidence. So anything basically that's happened from the last hearing up until now, when you get this decision from the federal court, you can submit new evidence to kind of help support your claim as well. So that's the second most common kind of outcome from what we're trying to do here in federal court. And again, that's called a reversal and a remand decision. And then the third possible outcome is that you get an immediate award of benefits. And this is a pretty rare outcome, just because it requires a lot of evidence to be in your file and no conflicts of any evidence to be in your file. And so that is a possible outcome, but it is pretty rare. So those are the three. You could get affirmed and dismissed, you could get immediate award of benefits, or you could get a reversal and remand decision.
Yeah. So a couple of things just for clarification for audience. Remand and reversal, meaning they send it back to the Social Security Administration. And technically, I think it goes back to the Appeals Council. And the Appeals Council kind of writes up and adopts what the federal court judge says. And then the Appeals Council sends it back to the Social Security judge. And often it can be the same Social Security judge who did the first hearing. Sometimes not, but often it is. And then basically saying, here's our instructions on how you're supposed to conduct the second hearing, right?
Right.
That's the most common thing that happens. Getting an award for benefits, immediate pay for benefits. We would love that for all our clients. But the judges, the federal court judges themselves, are more reluctant to just do that if they see cases that can be sort of fixed from a legal standpoint by the Social Security judge. And so they want to give a chance for the Social Security judge to fix it. And like you said, if the case is so overwhelming for a magistrate or a United States District Court judge, so overwhelming in evidence, and the standard is really high to get an immediate pay of benefits, where judges just seem more reluctant to do it. And the last point of clarification, if your case is denied and dismissed, there is still an opportunity to appeal to a higher court. So if you see denied, and then especially the word dismissal, what does that mean? That's just legal language. You still have an opportunity, generally speaking, if you've gone through all this process, to appeal to the circuit courts. And it depends on where you live. So generally on the West Coast, it's the Ninth Circuit Court of Appeals, and that's based in San Francisco. And then if you're denied there, you do have an opportunity to request an appeal to the United States Supreme Court, right? So, and that's a request. They don't have to hear your case. Where in United States District Court, if you file it, they got to hear it. And I believe that's to be true in the Ninth Circuit as well. If you file it, someone's going to have to make a decision. Not quite true at the Supreme Court of the United States. So those are the three main options that the federal court judges can do. And so now let's talk about how, because it's a common question, and I find it a little bit complex to explain sometimes to clients. I can't afford a lawyer, and this is a new case. How do lawyers get paid in federal court cases for Social Security?
Sure. So similar to actually the agreement that goes on down in SSA, this is also contingency fee based. But once you're in federal court system, there are two basic fees that go on. And the first one is called an EJA fee. And that is based on a federal court, federal government program called the Equal Access to Justice Act. And it allows attorneys to actually apply for some of the attorney's fees for the work that was actually done, for the hours that were put into those briefs, for reviewing, anything that had to do with the federal court appeal. We can actually apply to this federal government program for a certain amount of money so that it doesn't actually get taken out of the client's back pay itself. So that actually ends up saving the client money. And all you have to do to prove that is actually sign an affidavit basically saying that you have less than $2 million in assets. So that is one part of the fees that we do apply for. We can apply for those if you either get immediate pay of benefits in federal court or if you get that reversal and remand decision. So those are few opportunities where we'd be able to file for EJA fees.
Right. And what's the second one?
The second one is called 406B fees. And these fees actually are basically a 25% of a client's back pay. And why it's different from being down in SSA is once you're up in federal court, there's actually no cap anymore. So right now, when you're down in SSA, and if you win your case down at the SSA level, there's a cap of $7,200. It's not actually a true 25%, but once you get into federal court, we're actually entitled to that 25% true of your back pay. But again, it gets a little bit complicated here, but that's actually why we apply for the EJA fees, is so we can reduce that a little bit. And most of our clients at Evans Disability end up paying about 15 to 20% of their back pay towards us because we're able to actually apply for those EJA fees.
Right. And the 406B fee applies to once you've gone to federal court. So if you're remanded back for a second hearing or a third hearing, depending on how many times you go to federal court, if you're remanded back to the ALJ and then ultimately win your case at the Social Security level, because you were in federal court, that 25% 406B applies to your federal court lawyer who then is entitled to the true 25%. In addition to that, your hearing attorney is entitled to a 406A fee, which right now on June 7th, 2024, the cap is $7,200. So, like you said, that 15, 20%, maybe even a true 25%, depending on EJA, will go to the we'll go to the federal court lawyer, but your hearing lawyer, if you win the hearing, is still entitled to $7,200 or 25%, whatever's less. So those fees will start to look like, and this is why fees can get a little bit confusing once your case goes up to federal court, but there's kind of those two for the federal court lawyer, EJA, 406B, but sometimes your United States District Court lawyer is in an entirely different firm or an entirely different person than your hearings attorney. So and then that hearings attorney is entitled. Now, we keep a lot of that in-house, but it still works the same in essence. So yeah, that's the way sort of Social Security attorneys get paid. And you did a great job explaining that, because sometimes it can get a little bit, wait, we're talking about offsets and EJA. It can get a little confusing. Is there anything else regarding United States District Court appeals, frequently asked questions that you get asked, or anything else that you think we should talk about to let our audience know?
So one of the huge questions that I get asked is, I'm waiting so long for this. I've waited so long at the SSA level. I've waited, 1 to 2 years at the federal court level. Like, am I going to be entitled to fees for this entire time that I've been waiting? And the answer is actually yes. It actually goes back. Will be, if you do end up winning your case in the end, you will be entitled to fees for all this time that you were waiting. And it's very based on where your actual application date is and when you originally alleged your disability date for. So I know a lot of people get discouraged with the long wait times, but one of the big things to remember is that if you do win in the end, then your back pay will start from the date of your actual application. So that's an important thing to remember for sure. That's one question I do get.
Or potentially even in Title II cases could go 12 months prior to your application. So it sort of depends on when you're ultimately found disabled. But you're right. All the time in federal court adds on to that back pay, potentially, and again, it depends on when a judge finds you disabled or when the Social Security Administration finds you disabled. Well, listen, thank you so much for your time. I know that your time is limited. I appreciate all the work you do for our clients and for the firm and our team. And just, it's been a great pleasure working with you. And so, have a wonderful day.
Thanks, Peter. Great talking to you as always.